appeal in the Queen on the application of the Electoral Commission and City of Westminster Magistrates Court and the United Kingdom Independence Party.
My Lord, before my learned friend starts his submissions, there are two matters I would like to mention, if I may. Various questions were raised yesterday as to the test of eligibility to be on the register. And Mr. Yiginsu has, I think, burnt the midnight oil, and he's prepared a note for your lordships. I very much hope the matters that are set out there are not contentious, and they may be helpful in due course. I doubt I need to go to it at the moment. So that is that. And secondly, my lords, we've put before the court the Sainsbury's decision to which some of your lordships were party that was mentioned yesterday.
Mr. Beloff, we have the privilege this morning of having in attendance a most distinguished delegation from Israel, including the President and a number of justices from their Supreme Court. It's their good fortune to have chosen a period when they can expect a feast of advocacy.
Now, but I'm going to say that the fact doubled the tension of the Supreme Court. It now, your Lordship's observation, trebles it. But with that preface, my Lord, in our submission, this is in fact a straightforward case in which the Court of Appeal correctly interpreted the relevant provisions of PEPERA, including materially section 58, subsection 2, and reached the correct decision on the facts of this particular case, essentially for the reasons that they gave. The statutory scheme, which was the fruit of evolving consideration, starting with the Neal report, has, we would submit, at its heart, a principle that is both easy to understand and easy to apply. It provides for an identity between those who are entitled to vote and those who are entitled to give, which is a rationale in our submission quite as compelling as one which would seek to outlaw as donors those who could imprecisely be described as foreign. And in our submission, one should look not only at the starting point for this legislative reform, but to the place of arrival. And the mischief in the legislative language is this: parties should not receive monies from impermissible donors as defined in the legislation. My Lord, it is simple to check whether a putative donor is on the electoral register. The onus of making such a check is cast, again by entirely rational choice, upon the putative recipient political party. The sanction of forfeiture of donations received from an impermissible source also reflects an entirely rational legislative choice. That which one should not have, one should not keep. That is the foundation of the law of restitution in private law, and in our submission it is equally transportable to this public law context. This presumptive position, as we would contend it is, can of course be displaced by special facts. But in the absence of such facts, it is again entirely rational, not only that there should be forfeiture, but that it should be of the whole and not a part of the sum that is forfeited. The obligation to disgorge the entirety of the sum, not a penny more, not a penny less, in our submission is nicely calibrated. It is indeed the antithesis of disproportionate, and given the prehistory of the provision, it was clearly intended. Finally, my Lord, there is no conceivable assault on the democratic process in the Commission's construction, whether by reference to the protocols of the European Convention on Human Rights or to jurisprudence relating to the banning of parties in Turkey, or indeed otherwise, in giving effect to the unambiguous words of the provision. Finally, on the facts of which the Court has so far heard little, the party, the recipient party, was signally careless in respect of the duties imposed on it. And whether the discretion to order forfeiture was open-ended, as my learned friend contends, or presumptively to be exercised, as the Commission contends, in either circumstance, given the facts of this particular case, the exercise of forfeiture in our submission is inevitable. My learned friend said it was not his case that UKIP did not have to accept the rules as they were. The fact of the matter is that they failed to do so. I just mention at this juncture the so-called irrationality issue. My learned friend says that is not an issue that is open to the Commission in the Supreme Court. We say, on the contrary, not only is it open to us, but the Court of Appeal found in our favour on an argument that was advanced to them, and it is for him, in fact, to seek to displace their conclusion. There are no facts to be found, as my learned friend repeatedly says. They have all been found after a 3-day hearing before the learned district judge. Those which were not found, in his somewhat cursory judgment, if I may respectfully so describe it, were actually accepted as being on the record, and your lordships have in the conventional way the statement of agreed facts to which I may need briefly to refer. All that would remain is not the finding of fact, but their evaluation. And it's our submission, which I shall develop at the conclusion of my address, that unless my learned friend is able to displace the unambiguous conclusion of the Court of Appeal, that whatever the outcome of the issue of construction, it would be irrational of the person seized with the power to forfeit not to exercise it, the conclusion would be, in our submission, that this court should remit the case to the Westminster Magistrates Court to determine, in accordance with the ruling of the Court of Appeal, which on this hypothesis this court would have endorsed, which would indeed be a formality, since no doubt...
Mr. Beloff, which paragraph in the Court of Appeal's judgment dictates
50,
that?
50.
50, but I mean, then we have to remember that the Court of Appeal considered the entire case on what was then the accepted basis that it's all or nothing. If you're right about that, well then this rationality point may carry some substance. But failing that,
I entirely agree. I mean,
you accept that?
Yes.
But it also on the basis of their view that there was some form of presumption.
Well,
quite apart from the all or nothing.
No, with great respect, my Lord, when one looks, there were two arguments that were advanced to the Court of Appeal by the Commission. The first was the presumption argument, the argument of construction. The other was, assume we are wrong on the presumption argument, and it is an open-ended discretion, qualifying that in the traditional public law way. Nonetheless, on these facts, there was only one conclusion. It's indisputable that those arguments were both advanced. If necessary, I can show your lordship.
Where were they accepted,
passages.
though, is the question.
They were accepted in our submission in paragraph 50.
Well, where did they accept this, the second branch?
The irrationality
where about in paragraph 50?
In the final lines of the judgment. But, my Lord, can I revert to that? Because I don't want, as it were, to take it out of turn. Your lordships are obviously more interested, if I may put it this way, and it's obviously the function of a Supreme Court to pronounce on general issues of law. And the Commission's position is this. Firstly, of course, we wish you to accept our submissions on the points of construction. Secondly, if the Court declines to do so, nonetheless, we will have the advantage of authoritative guidance for the future conduct of our responsibilities. But thirdly, of course, we do wish to win this case, which is why it's important for us to persuade your lordships that the irrationality point is live before your lordships, or would be live, taking account of the hypothesis advanced by my Lord Simon Brown. We wish to win it, not least because of the potential, I emphasise that word, potential cost implications were we not to do so. So, my lords, we're just simply putting, as it were, the a la carte menu before your lordship. May I deal with the two issues of construction, the presumption issue and the all or nothing issue, which my learned friend, in our respectful submission, quite correctly reordered in his oral submissions as contrasted with the printed case. Now, although my learned friend amalgamated the two submissions from time to time, in our respectful submission, they are two discrete issues and can be treated discretely. I want, if I may, to retread, but expeditiously, the path trodden by my learned friend in relation to the travaux, that is to say, Lord Neil's report and the white paper. Firstly, because my learned friend did not read all the paragraphs which our submission are helpful, and secondly, because we don't always agree with the interpretation that he placed on those paragraphs which he did read. From time to time, it appeared to us as if my learned friend was in some kind of time warp. That is to say, that what Neil said informed the construction of the Act in the sense that the Act was simply a modest reconfiguration of Neil. We say, with respect, that with the Court of Appeal, that the changes that were made between Neil and the white paper being perfectly reflected in the legislation, were of considerable significance. And one has, therefore, as an aid to construction, not only the clear language, as we would submit, of the statute, but the fact that one may juxtapose that language with what Neil proposed in order to understand what change was envisaged by the white paper. So if we may start then again with Lord Neil's report, which is in the third part of the appendix, and just to certain of the paragraphs in it. Part 3, sub 2. And I wish, if I may, to start at page 255 of the volume. And my learned friend quite correctly says, and we don't shy or shrink from this, that Lord Neil was at this juncture of his consideration concerned with whether or not foreign donations should be banned, and my learned friend read to your lordships or referred to your lordships at page 252 to the arguments in favour of that conclusion. At 5.18, something that was read, Lord Neil touches on the difficulties in actually defining a foreign donation. And at 5.19, which my learned friend did not read, what he said was this: this and other similar difficulties persuaded us that it would be more constructive to approach the problem from the opposite direction and to attempt to define what was to be regarded as a permissible source from which donations may be received. So that there one had the concept of a permissible source as being at the root of the legislative provisions, and the issue which concerned both Lord Neil and indeed the government in their white paper was the definition of a permissible source. At 5.28, one finds what, in our respectful submission, is the approach of Lord Neil, and this was in itself accepted in the white paper and the legislation. That's at page 257. Any person or body which did not fall within the definition of a permissible source would be excluded from giving to a political party. Then he goes on to deal with on whom the responsibility for ensuring that donations were received from only permissible sources was to lie. This again was a passage my learned friend did not read and certainly did not emphasise during the course of his submissions, much of which, insofar as he referred to fact at all, were on the innocence, if I may put it this way, of Mr. Bown, rather than the way in which UKIP did, or in our submission clearly and indeed admittedly did not, discharge the obligations that were imposed upon them. And at 5.31, at 259, he says, we follow the approach taken in Chapter 4. This responsibility must be placed on the shoulders of the various political parties, and he then elaborates that and envisages Rule 28 in the box beneath that paragraph, where he suggests the responsibility for ensuring that donations are received only from a permissible source should be placed on each political party. the designated responsible officer of the party would be required to certify the position to the Electoral Commission annually when reporting on the donations received. And then finally, one comes to 5.42, which is the enforcement and the penalties. This, of course, was read, and one notes that there was to be a criminal sanction proposed requiring mens rea, deliberate acceptance of a donation from a source outside the definition of a permissible source, and the sanction would be a sum not less than the donation should be liable to forfeiture from the party's funds. And in our respective submission, that was the germ of the concept, as my Lord Clerk suggested in the course of debate with my learned friend, of the notion of a sum of equal value. But then Lord Neil envisaged a sliding scale that penalties of up to 10 times the overspend might be levied. So there was going to be a greater range of discretionary powers in the criminal court. And then the forfeiture power would also, a forfeiture power would also apply even if the receipt were innocent or inadvertent, although the courts could clearly take into account the degree of culpability in setting the level of forfeiture. So that there one saw that forfeiture didn't depend upon innocence or inadvertence. In other words, one didn't have to be guilty for the forfeiture power to be exercised, although Lord Neil envisaged the possibility that the degree of culpability would be relevant in setting the level of forfeiture. Now, against that background...
I mean, just pausing at that paragraph,
yes.
I mean, the explicit concept of a sum not less than was not carried through in Section 58.
No, it wasn't carried through as such.
No, I mean, your case would be easier, you would say even easier, if it had been on the second issue, which in my mind is actually pretty intimately linked with the first, but there it is. I mean, we haven't got not less than. And the other point about that paragraph is that certainly Lord Neil saw no problem in the concept of forfeiture in part.
Yes, true. And what we respectfully submit is that one has to appreciate the extent...
Up to 10 times. Does he envisage part forfeiture? I thought he was envisaging, instead of 10 times, it might be 6 times or 3 times or something.
No, I didn't understand him to envisaging part forfeiture, nor did I understand Lord Simon Brown to be putting that to me as a proposition.
I see.
Not less than means the minimum is going to be that which you receive. It could be more in the criminal context.
I know, but it's the last 3 lines. Is that not... I had understood the last 3 lines to contemplate something akin to Section 58.2, in other words, a non-criminal power of forfeiture. And if that is right, with respect, I do think level of forfeiture
Your Lordship is right. I had confused in my response to my Lord the criminal and the civil. Your Lordship is quite right. Insofar as one is touching on civil, the notion of level of forfeiture can only relate to how much rather than whether.
Yes, but is it, I mean, sorry, Mr. I think that Lord Brown thinks that you might say it was 50% of the sum.
Exactly.
Whereas I think you might think, well, it might be 100% or 200%, but it couldn't be 50%. I mean, I may be wrong. I mean,
if one talks about setting the level of forfeiture rather than deciding whether to forfeit or not, in our respectful submission, it appears to envisage some kind of sliding scale which will reflect the degree of culpability. But in any event, what's important from our point of view is to understand where the white paper and the legislation diverge.
Well, I know.
That does emphasize.
I appreciate that. But I mean, one matter we touched on, and at some stage we'll no doubt have to grapple with, is whether you can have such a thing as forfeiture in part.
Yes, that's...
And all I'm saying is, that would appear to suggest that Lord Neil thought you could. I agree they didn't. That's all.
Simply because everything except the last three lines is dealing with either deliberate acceptance of an improper donation or attempted evasion of the rules. Yeah. And the basic principle in the last three lines is dealing with other situations and seems to postulate simple forfeiture, not the 10 times, which is for deliberate evasion.
Yes, I mean, it's interesting in a sense that there isn't a clear distinction drawn between civil and criminal in that particular paragraph, or indeed in the Rule 31.
No, I mean, that's perfectly true.
Which is
picked that up
subscribed.
yesterday.
But also, there's an anomaly in using the word forfeiture in this context at all, isn't there? Forfeiture normally reflects the loss of an existing right or property. To say you forfeit 10 times something is a very bizarre idea. It's really equating forfeiture to a fine.
Yes, it is. It is. I mean, and indeed, the language of penalty, which is used in justice
penalty, not forfeiture,
emphasises that point. Yes. But my concern is to remind your lordships that Neil was not accepted in a number of ways. And as I say, that reinforces what we say is the natural and ordinary meaning of the vocabulary that was actually used in the legislation.
Well, you say it was not accepted, and that seems to be the problem. If it was not accepted, it was not accepted by whoever drafted the white paper in extraordinarily anodyne terms of apparent acquiescence.
Well,
by somebody who doesn't really seem to have grasped the minutiae of the paragraph we've just been reading. Still, I suppose it was ever thus.
Graftsmen lack the collective wisdom of 7 members of the Supreme Court, and I'm not to be blamed for that.
Mr. Belloff, can I just? I mean, this has been worrying me slightly all the time we've been talking about it. It's never going to be a good moment to ask it, but I'll just ask it now. They talk here about forfeiting a sum from the party's funds. Yes. Now, parties seem to exist with negative amounts of funds. If they have no money, in fact, have only debts, how does the forfeiture work? I mean, forfeiture is usually if something you see a car and you take the car and you forfeit it to the state. I mean, how does it work, Mr. Beryl, in the Commission's
how
view?
does it work actually
if there are no money
to the legislation?
Yeah, in the legislation, yes. How does it work? I mean, if the party has no money,
Yes.
you pronounce an order, what happens?
It becomes a debt,
It's just a
civil debt, which would be enforceable, rather like, as it were, one used to have the football cost, the football pool's order for costs.
That wouldn't be true of a forfeiture of, say, a car, would it?
No.
Somebody stole the car before the time to forfeit it. You couldn't forfeit it any longer because it had already been stolen, or I suppose it blew up.
It's true. I'll come to the legislation in a moment, but it is, of course, true that those who drafted it made one of two assumptions. Either that in the orthodox case, one would still have the money which had been given by the impermissible donor in the bank account, albeit it would be fungible, one wouldn't identify the very coins, as it were. Alternatively, that all political parties were so rich that they would have the assets in any event to satisfy it. As far as I'm aware, Parliament didn't grapple with the issue my Lord Roger put to me. But I assume that the position of the Commission, were they to institute for forfeiture proceedings and were to succeed against a party that was not presently in a position to forfeit a sum of equal value to either the money or the services or whatever was provided within the meaning of donations, then it would be a debt which would be enforceable.
I don't think Mr. Lawrence disputed it, but I just wanted to...
That's how I would understand it to work.
So it's not really forfeiture at all.
Yes, is it not clear that forfeiture was the wrong use of language in this paragraph? Because what Lord Neil is talking about is a minimum penalty of the value of the donation
I
to
agree.
be increased tenfold if it's deliberate. Forget about whether it's criminal or civil, but if it's deliberate, he's proposing 10 times the donation, which is a penalty, not a forfeiture at all.
Yes, indeed, one might say that the language of forfeiture was inapposite in the legislation itself, because again, the elementary position would be you receive the money, you shouldn't receive the money, you're forced to give it back. In the real world, that situation wouldn't happen. Of course, as your lordships will appreciate, this being the first time the forfeiture machinery was ever engaged at all, there's been no experience of the problems that your lordships have
But
now
the real issue, I
envisaged.
think, is what is the significance of the legislation having carried forward what I think is probably a misuse of language?
Well, one has, with respect, to give it some kind of meaning, and if your lordship say the word forfeiture was inapposite, civil penalty might actually reflect more accurately, since it is distinct from the criminal sanction, which is elsewhere provided for. That's how it will be operated. But what I hope your lordships will resist is a temptation to say this is meaningless, inoperable, and therefore Section 58.2 can never be engaged.
But your basic position, as I understand, Mr. Beloff, is that all it is taking away from them something which they ought not to have had
Absolutely,
in the first place.
yes.
And that's your basic position.
That's the basic position.
It doesn't go back to the donor, but it's taken away from the
Absolutely.
recipient.
I mean, of course, in many ways, the very notion of forfeiting something of equal value doesn't do justice to the ordinary meaning of forfeiture, because, as my Lord in the Chair, the Lord President suggested, usually it means that you have to surrender something that you identifiable that you already have.
Mr.
As in the
Beloff,
car cases.
on this topic, can we look perhaps a little more closely at 542 in conjunction with 461? Because 542 begins, in essence, what we said in Chapter 4, paragraphs 460 and 461 should apply. And 460 and 461 were dealing with two different things. They were dealing with criminal sanctions and forfeiture of donation. And if you look at 461, the reporting obligations should be backed by criminal sanctions.
Yes.
So drafted is distinguished between inadvertent and deliberate failure to report. In the latter case, those responsible should be fined or imprisoned. So this is personal criminal responsibility. And then, in both cases, the court would have power to order the defaulting political party to forfeit a sum not exceeding the unreported donation. And then when we get to 542, in the middle, we see criminal sanctions should attach all responsible, and a sum not less than the donation should be liable to forfeit
So there's a
from
confusion.
the party's funds.
Yes, there's a confusion between floor and ceiling in that. Well, perhaps it's a mercy that all that I need for the purposes of taking your lordships to the Neil report is to say it isn't how it ended up in the legislation. To the extent to which the legislation improved the position may be moved. But can I move now to the white paper? The white paper is in the same volume, and in Appendix 3 at tab 1. And if one may start at 1.5, which my learned friend did read to your lordships at page 6. The committee's report endorses and develops the government's proposals for ban on foreign donations to political parties. That's the Neil Committee being referred to there. The scheme of control which the committee proposes is again a detailed one, with significant implications for political parties as well as for the regulatory apparatus. Now, this is the first sentence in which one sees the government imprimatur. The government agrees that a regulatory scheme of some rigour is needed to enable the restrictions to be enforced. And there one has at least a factor to be taken into account when one is construing Section 58.2. It is the enforcement mechanism of the ban upon receipt of donations from impermissible donors. Then a proposal set out in the white paper.
Well, we might say enforceable mechanism on the ban on foreign donations, which is what it starts off with. I mean, that's the alternative approach, isn't it?
Well,
It's all about prohibiting foreign donations.
That's where it started, my lord, but one can't, as it were, ignore the fact it's not where it ended. Now, if what I put as the basic rationale, he who cannot vote cannot give, struck your lordships as being, as it were, aberrant, some kind of, as it were, proxy just put in because one couldn't capture the notion of foreign donations, I would understand that. But in our respectful submission, it's simply a step forward. Neil said, let's look at it from the other end. Who should be allowed to give, rather than seeking that?
But that was with a view, surely, to implementing the policy of banning foreign funding of political parties.
That's where it started. But in the end, Neil came up with a refinement, eligibility.
But for that purpose.
Well, one says for that.
Or primarily for that purpose.
Well, it's primarily for that purpose. But in our respectful submission, it went further, A, by looking at it from the perspective of who is entitled to give, B, embracing within the concept of who is entitled to give, the concept not merely of someone entitled to vote, but someone who actually could vote.
Mr. Beloff,
What is wrong with that?
A company cannot vote, nor can a gentleman who is dead.
No. My lord, I'm not going to dispute either.
No. But surely that gives a lie to the suggestion that there's something magic about one's ability to vote that justifies you in giving donations, which doesn't...
No, I'm not saying it's magic. What I'm saying is, in terms of individuals who can vote, it's perfectly logical. I don't have to say that it's inevitable. All I have to say is that it has a rationale. It isn't simply cosmetic. It started, as I say, obviously with stopping those who did not have a stake. But the question is, what do you mean by a stake as well? If you're not, for example, prepared, although eligible to vote, to take the steps to actually convert that eligibility into an entitlement, it'd be perfectly rational for the legislature to say those persons, as it were, haven't shown sufficient interest in exploiting the stake that they would otherwise enjoy in this country.
Well, the genesis of the Neil report was the government's proposals for a ban on foreign donations. Now, do I understand you to say that that really has evolved through the white paper to a different stance, and that is, if you're not entitled to vote, you're not entitled to give, subject to the exceptions that my lord has referred to. Well, where does that articulated, that transformation?
In the legislative language.
But not in the white paper.
Not necessarily in the white
Mr. I mean, surely what the white paper 4.5, 4.6 makes plain is it's not because we're going to hang this all on whether the chap could actually vote when he gave. We're hanging it on. You can police the whole scheme so much more easily this way. It's a policing provision. I mean, I don't underestimate its value as such, but it's that rather than, I mean, I think you, my lord and the chairs, riposte about the dead and the corporate rather answers a suggestion that Parliament is saying, well, fine, you can give if you can vote, but if you happen not to be on the register, well, that's it.
Well, and indeed, the paragraph 4.5.6 and 4.6 are in the context of the discussion on sources of funding, which begins in paragraph 4.1 with the welcome of the Neil Commitment's endorsement in the context of its wider proposals for the manifest commitment to ban the foreign funding of political parties.
All that I accept, and indeed I wasn't going to shy from reading, but your lordships have obviously, as it were, pre-read and reread 4.1, 4.5 and 4.6. I don't dispute that this was the starting point, but since the legislature, for whatever reason, determined to define permissible, impermissible donor in a particular way, in our respectful submission, the legislative choice has to be respected. And when one asks what is the mischief is reflected in the legislative choice, and one might say one of the consequences of that is, of course, that persons who one might loosely call foreign would not be eligible to give. But it's not the only consequence. And one can't rewrite the statute in that way. In other words, what we say, it's not a proxy, it's a substitute, an evolution.
I mean, you don't accept the suggestion of primary and secondary mischief. I was thinking of an analogy with driving. As a matter of policy, people shouldn't drive cars if they're not competent to do so. And so you say that you've got to have a driving licence. The primary mischief is that people shouldn't drive who aren't competent. Secondary mischief is that people shouldn't drive who haven't got driving licences. So if you drive without a licence, you commit an offence, an absolute offence. And then there may be a requirement, if you have an accident, to produce your licence at a police station within 24 hours. So there's a further tertiary offence. But the primary object of the exercise is to make sure people who drive are competent.
That I'd accept, but this novel, in analytical terms, concepts of primary, secondary and tertiary mischiefs, I would emphasise them now. I mean, they're all mischiefs, and one shouldn't, as it were, undermine the legislation by seeking to construe it in a way that's inconsistent with any of those mischiefs, whatever position they have in the hierarchy of mischiefs as they are.
So, of course, the odd thing is that nobody is really doubting that. I mean, nobody suggests that there aren't, that the rules aren't the rules and the rules must be complied with. The question is, what did Parliament intend when it came to penalty?
Yes, that's true. We'll come on, if I may, to penalty. But of course, once you've got a regime that is meant to be enforced, you have to appreciate that to, as it were, apply it with a lighter touch, because you could say, well, so-and-so might have been eligible or would have been eligible to give, this was an accident. Don't forget, and this is something that my learned friend did not emphasise, the responsibility is placed upon the party. We make no criticism of Mr. Bone, who is free, subject to other legal constraints, to give to whom he likes. It's the party which was responsible for determining whether or not he was or not eligible. And as is absolutely clear, not only did they signally fail in that, but actually they've taken certain steps that made them less able to fulfil their statutory obligations.
But on the other side's case, all those would be relevant factors in deciding what an appropriate penalty would be.
Yes, well, we'll come to. I mean, I understand with what I need to engage. Can I just then go to the penalties provisions of the right to say?
Just before you do that, Mr. Belloff, I mean, there are two limbs actually to this. One is you get money from somebody who is not a permissible donor, and the other limb is that you get money from somebody where you cannot identify the person who gave it.
Yes.
Now, what is the purpose of the second limb? Is that just to back up the first limb, or is it? What is the purpose? Is it a separate purpose?
Because if you can't tell that they're a permissible donor,
is that the only reason?
Well, I can discern no other.
So it's just a backup.
It's a backup, and it's again of some importance because it reinforces the significance of the concept of permissible donor. In other words, not enough to know that he is not a permissible donor or ought to know, but if you're in a state of uncertainty, as it were, the balance assumes that he should not be treated as a permissible donor.
It's just a backup.
That's the way I would put it. Then your lordships will see then, it's at 4, 1, 3, 4 and 5, enforcing the ban on foreign donations, and they refer to the Neil Committee's report. And then criminal sanctions have been referred to, and in addition to those, the government also accepts that where the proposal, that where a party is found to have accepted a donation from other than the permissible source, it should be liable to forfeit that sum. The prefatory paragraphs are dealing with matters other than the receipt of impermissible donations, other forms of deliberate evasion, and etc. Clause 51 provides for a power of a magistrate's court, or in Scotland a sheriff, to order forfeiture of a sum equal to the value of a donation received from other than the permissible source. So there's a clear contrast made with the notion of more than the sum, and in our respectful submission, actually, it's another way perhaps of putting not less than the sum, but it imposes actually both a ceiling and a floor, and they are actually the same.
Does it necessarily? I mean, it should be liable to forfeit that sum, and then it says there should be a power to forfeit a sum equal to. I'm not sure that does equate with not less than.
Well, be that as it may, but my Lord Mance does touch upon an important aspect, which is this. One has to distinguish between two elements of the provision as finally enacted. Point A, should there be forfeiture at all? Point B, if so, of how much? My Lord Walker raised the issue in the course of argument before the adjournment yesterday as to whether or not the concept of being liable to pay something meant that one was going to be obliged to. We respectfully agree. It does not. The fact one is liable to pay something doesn't mean that one is going to have to pay it. But here, the question of, as it were, liability is the question of whether forfeiture should be ordered. The question of how much, we say, is dealt with by the statute because it says a sum equal in value to, or of equal value to. But I'll develop that, if I may, a little more detail at a later stage of the submission. And then what's interesting is, that the government anticipated that the sum equal to the value would apply whether the donation was accepted knowingly or not. In other words, innocence was going to be of no excuse in that, and nor was there to be any form of sliding scale. And they, at any rate, construed, or maybe improved Lord Neil's recommendations by making it clear that there was to be the concept of a civil forfeiture order, as they described it, which it found its final incarnation in 58 sub 2. So, what the Court of Appeal said in our respectful submission in analysing this change was entirely accurate. And can we just turn then to...
Just before we do that, can you just help me?
Yes, I'll do my best.
At 4.15,
yes,
page 28,
yes, 28, yes.
What is the reference, the R31? Where...
That's back in Neil.
It's back to paragraph 5.42.
Yes,
page 261.
Exactly. That's the one.
Which we noticed yesterday actually didn't include in terms the proposed civil forfeiture order that had been heralded in the last three lines of 542.
Right. Exactly. Yeah.
So really the first sentence is very difficult to follow.
It's very difficult to follow literally.
But
I mean, I suppose they call it R31 because they just treat it as encapsulating 542.
Point of reference. It's a point of reference.
Yeah.
I don't think... I think, however critical one might be of the language used both by Lord Neil's committee and the White Paper, what is clear is that both of them envisage there being a duopoly both of criminal and of civil sanctions. And certainly the White Paper and the government interpreted Lord Neil as having had both in mind.
But do you accept, that the expression it should be liable to forfeit that sum is consistent with introducing a provision which gives the court power to order the forfeiture of a lesser sum?
No.
You don't? I thought you did.
No. You say liable and power simply goes to whether you have any right of forfeiture at all. Yeah.
Yes, there are two separate aspects.
If you do, then it's got to be an amount equal to.
That's right. That's the way.
That's the next sentence.
That's the way I put it, my lord. And we'll come, of course, to the section itself, just to reinforce that. So can we then just come very briefly to what the Court of Appeal made of this at tab 2 of part 1 of the appendix at paragraph 33.
Paragraph
33 through to 35.
Where have we gone to, Mr. Bellon?
Paragraph 33, page 15 of part 2 of appendix 1. Clearly, the Neal Committee decided it was appropriate to ban foreign donations, but because they could not be satisfactorily defined, the committee approached the problem from the other end. It decided to recommend donations should only be received from a permissible source in the case of individuals, those on the electoral register and those entitled to registration. Parliament accepted the general approach, but restricted entitlement to registered electors because entitlement would then be easier to check and those entitled to registration could easily take the steps necessary to obtain registration. That was quite a significant change. Even more significant was the change in relation to the forfeiture proposals. The Neal Committee recommended for deliberate acceptance of a donation from an impermissible source, there should be liability to forfeiture of a sum not less than the donation from the receiving party's fund. In significant cases of attempted evasion of the rules, the penalty levied could be up to 10 times the overspend. It was envisaged the forfeiture power would be available even if the receipt were innocent or inadvertent, but the courts could clearly take into account the degree of culpability in setting the level of forfeiture. That's a quotation. I'm inclined to agree with Mr. Newman, who appeared below, that the Neal Committee probably envisaged the courts having quite a wide discretion in relation to forfeiture, but in the White Paper and the statute, this position changed. The proposal there should be power to forfeit an amount greater than that received was abandoned without explanation. But paragraph 4.15 of the White Paper, which we just perused, clearly envisaged a power to order forfeiture of a sum equivalent to all that had been received, that sum, whether the sum was accepted knowingly or not. In our respectful submission, that was a entirely proper analysis of both the changes and of their significance. So if we then may come to Purpura itself, which your lordships have in the authorities drafted volume 4 at tab 50, and just to make a few points en passant in relation to the provisions that have been read, one goes straight to section 54 under chapter 2, registration on donations to registered parties, and one sees then that there is a concept of permissible donor, the antithesis of impermissible donor. Your lordships have the phraseology well in mind, but I just note this, as did indeed the Court of Appeal at another juncture of their judgment. An individual who is registered on an electoral register, someone who is making that a permissible donor will certainly exclude what one might generally or loosely call foreigners, but it will exclude more than those, because there will be persons who are eligible to vote in parliamentary or in local elections, the criteria being modestly different, as my Lord Mance observed, but nonetheless, because they have not registered, will not enjoy that particular opportunity. So it casts a wider net, the definition of permissible donor in relation to individuals, and in our respectful submission, I repeat, this is not a proxy, it's a substitute and development. What we indeed submit is this. What was fundamental to Lord Neal's analysis was the concept of permissible source. One was not to accept donations other than from a permissible source. What varied between what one might call pre-Neal, Neal, and the White Paper, and eventually the legislation, as to what was the definition of the permissible source for those particular persons. My Lord, Lord President pointed out entirely accurately, of course, that corporate donors companies cannot vote. Obviously, both limbs of the definition of permissible donor, both in relation to individuals and into companies, require some form of what one might loosely call United Kingdom connection. In both cases, such connection is necessary, but in the case of individuals, by itself it's insufficient, because through legislative choice there's a tighter criterion, that of registration on the electoral register. That's what Parliament has then decided. Then one sees at paragraph 50, section 56, subsection 2, one notes there, in fact, the entirety of section 56 makes it clear that the obligations upon to ensure that impermissible donors do not give are laid upon the registered parties. That's indeed consistent with the passage that I read from the Neil report and has been carried through. So what's important when one comes to consider the potential sanctions is not, as it were, the extent to which the donor has or has not behaved properly, but the extent to which the registered party has or has not behaved properly. And one sees there that one has the 30-day period of grace in which, if one does not return the money immediately, one has 30 days in which...
Does the obligation to return cease on the 31st day?
The obligation to return would cease on the 31st day, yes.
Is that clear? I mean, ordinarily, if you have an obligation to do something within a certain period, you may be in breach of it. But the idea that the obligation to return lapses on the 31st day is curious.
No, I don't think that I think I answered too quickly. I think the obligation to return remains, but if one hasn't done it within that period, one is going to be liable to the sanctions.
I don't think that's right. If you look at section 56, subsection 5, because after the 30 days, you're taken to have accepted the money.
Yeah. Well, you're taken to have accepted the money, and therefore you're vulnerable to the sanctions for taking the invisible donor. That's not necessarily inconsistent with a continued obligation to return.
But it couldn't be enforceable, could it?
Well,
I mean, my Lord's proposition is that after 30 days, someone to whom someone could complain and say, you should still be performing this past obligation, but that can't be.
No, I don't think that could, no. But as I say, I mean, you've got an obligation to return in the sense that you still are not entitled to have it.
Well, that's not the same thing at all.
Sorry?
That's not the same thing at all.
No.
You've undoubtedly breached your obligation to return it within the 30 days. Having breached it, it seems that the obligation must lapse and no one could enforce it in public or private law.
They couldn't enforce it, but were you not, I mean, actually by that stage, of course, you're probably vulnerable to the sanction of forfeiture, but I suppose, at any rate on my learned friend's construction, you might say, well, I'm very sorry. I have returned it late, but I no longer have it. Now, that may or may not be a sufficient answer to a forfeiture application because, indeed, as history relates in relation to this particular party, if you just return it to someone who's impermissible donor, they can pass it to a permissible donor and back it comes. But there would be a possibility, which I think Sir Paul Kennedy in the Court of Appeal recognised, that you intended to return it within the 30 days, but an outbreak of swine flu decimated your staff, and therefore you failed actually to do it in those circumstances, exceptional as they might be. The Commission might not take action, and if they were to take action, the magistrate might not enforce the sanction. But in any event, I mean, the fact that you've got a period of 30 days grace doesn't actually undermine the policy of the Act. All it means is that you're given the opportunity to check within 30 days whether or not the donation is from a permissible donor. And I think my Lord President referred to my learned friend. I mean, if you return it within 30 days to the donor, even though you've lost that which you otherwise would have wished to have, no one is suggesting there's a breach of Article 1 of the First Protocol in that particular situation, even though, as it were, there's been, in one sense, a deprivation. In any event, the important aspect is here that you're given the 30 days grace, but that the inquiries that you can make, which you're expected to make under 56.1, are relatively, they are easy to make. We deal with this in our own printed case. If your Lordships would be good enough to turn to that at tab 3 of the core bundle at paragraph 40.
I think it's tab 4, isn't it?
Tab 4.
40?
Paragraph 40. Just during taking the second sentence, I don't understand any of this to be controversial in itself. The inquiries envisaged by Section 56 are not difficult or expensive. Once a donor provides the address at which he or she is recorded on the electoral register, that can be checked by looking at the appropriate register. Registered political parties, including, of course, UKIP, are entitled to free copies of registers in hard copy and in electronic form. Representation of People England was Regulation 2001, Regulations 102 and 106. So there's really no difficulty at all, which is another factor which is relevant when one comes to consider the proper disposal of this particular case. The next matter...
I mean, in practice, how does one check? I mean, might you not telephone whoever it is at the local authority who keeps these registers and say, could you just check whether Mr. Bowen is on it for me? I mean, could that happen?
Yeah, I mean, it could happen, yes.
And I mean, assume that you do so, and then they mistakenly say he's on when he isn't.
Yes. Well, that might be an exceptional circumstance. It may be an appropriate juncture just to look at a passage in the judgment of the Court of Appeal, which my Lord Simon Brown found on the face of it not wholly intelligible, which is at the start of paragraph 50, which it attributed to me an example of what we said was an exceptional circumstance, or a party which was misled by an inaccurate entry in an electoral register. What I don't understand that to reflect the submission I made. There are two possibilities of an exceptional circumstance. One might be, as it were, that the entry was actually fraudulent, in which case I don't want to go into the legal technicalities. If possible, it might not be counted as an entry at all. But what I think Sir Paul Kennedy had in mind was a submission that I borrowed from what Mr. Dillon said before the district magistrate, which is at page 727. This is in appendix.
This will be C and D.
Yes, part 2, C and D.
727.
727.
Tab 9.
Yeah. He was being asked what was exceptional circumstances, and what Mr. Dillon said at line 2. I can think of the example when you go to the electoral register and you're told by the electoral registration officer, you're informed that someone is on the electoral register, you've done what you're supposed to do, and if you do it telephonically the same way, you check the register, you're told they're on the register, it later turns out that is wrong, that is incorrect, they were not on the register, and that might be an exceptional circumstance when forfeiture ought not to be ordered. I suspect that that's what Sir Paul Kennedy had in mind in what was otherwise not entirely intelligible observation there. It's possible, I can't check because there's no transcript, it's possible
So it's an inaccurate report.
Exactly so, an inaccurate report. It's possible that we did have some discussion what would happen if it were a fraudulent entry. Would that qualify as an entry at all? But as I say, that's more arcane, and I suspect it's actually just a reflection of what Mr. Dillon said. But the short point is, I mean, of course, one could make inquiry in that way, but the representation of the people, England and Wales regulations, actually says, well, you can do it electronically, so you can actually see something. It's probably safer, if I may put it, to do it that way. And that may be one of the factors that will be taken into account by the Commission in deciding whether or not to put the machinery in motion.
Would it be a relevant factor for the court?
Well,
and are they the same or a different thing?
Well, can I, as it were, part? I'm not going to shrink from it. I'll do that, if I may, in due course, when I just conclude just a few sporadic submissions on the Act. I mean, the other feature of 56, as one passes by, is that originally there was a strict liability criminal offence, but now Parliament has been merciful and has, in the 2009 Act, included a defence of, as it were, reasonable diligence. But again, it's instructive to note that, as it were, strict liability was a theme running through, as we would say, both the civil and the criminal sanctions, and in relation to the civil sanction, of course, echoing the language of the White Paper, inadvertent or not. Then, of course, one has 58.1, that's 58.2.
So you can avoid a fine, can you, if you satisfy subsection 3A
you can
as
now.
the party, but you're still liable to forfeit the whole thing.
Exactly.
On your analysis.
There's been no change in that.
Well, that's a little odd in itself, isn't it?
Well, whether it's odd or not, that's the way the legislature have decided. And the response, well, it's very easy, I know, to criticise those who enact legislation.
This is a process of construction,
yes,
which involves looking at
yeah, but all I'm saying is that one
essential good sense of it all.
Yes, but
perhaps.
Well, maybe, but one can quite understand why one should discriminate between criminal and civil sanctions.
It's difficult to see the difference between a civil penalty and a fine.
There's a stigma of criminal.
It's the ultimate logic. Of course, if you're completely innocent, you don't have to commit a criminal offence, and there's no criminal penalty. But the one thing you do have to do is to actually make sure you don't benefit from what you should have not had.
Yeah. I do think, in any event, one doesn't want to go into a disquisition upon the difference between criminal and civil penalties, but obviously, on any view, one would prefer to be liable to a civil penalty than a criminal penalty.
Well, I don't know.
Well, in any event,
not under this statute.
The legislature has, well, one wouldn't have the taint of criminality attaching to one.
The Treasurer is a pretty exposed position, isn't he?
Yes.
Because
he's the person. Yes,
he's guilty of an offence, and in order to get the benefit of the new exception, he has to show that all reasonable steps were taken by or on behalf of the party, not necessarily by him personally.
Exactly.
Yeah.
He is vulnerable. He's in the eye of the storm, as it were. Perhaps one, again, a point I think your lordships are alert to, but it is perhaps worth noting that each donation received is subject to this regime. So whether, as it were, you give £100,000 in a single payment, or whether you give instalments of £10,000 in relation to the latter on each occasion, you are obliged to identify whether someone is or is not a permissible donor. Given, as I shall show your lordships, if I may just introduce what's common ground in the chart here, there were, as it were, plenty of opportunities for UKIP during the time Mr. Brown was making these donations as an impermissible donor to say, well, wait a minute, should we just check again? It wasn't as if he gave one single sum. They mistakenly thought he was eligible and then never, as it were, had a legislative obligation on them to recheck. Anyhow, it is for individual donations. One also notes...
So was he saying, I am on the electoral register, this is my address? I mean, I'm just looking at the Schedule 6, paragraph 22, page 203. I mean, if you remember, if you remember, this is the bit that's referred to in 56.1.
Yes.
I mean, if you go to, 56.1 tells you that you've got to check whether he's a permissible donor.
Yes.
And if that appears so, all the details as required. And then we look at page 203 and we see what he's got to do.
Yes.
What the report has got to do, I'm sorry. But the report presumably gets it from him. So what was he saying, Mr. Bow, when he gave these various instalments? Do we know?
Well, we actually do have his statement. And as I say, the district judge said it's entirely unclear whether A, he forgot to re-register, B, he put it in the post and the post lost it, C, it arrived at the local office and they failed to put him on the register.
No, I'm sorry, that's not my question.
I see.
When he was giving the money,
yes,
he was giving an address at the same time. I mean, he was saying, was he not, or was he not saying, I'm on?
I don't think that was ever explored. That wasn't explored in the evidence, I think, is the answer I'm getting from Mr. Dillon. We have got his statement. Perhaps it might be, since the point we raised, just worth looking at it, because my learned friend actually was asked at one stage about what he did and didn't perhaps give a precise answer reflecting the evidence.
But, I mean, you do, no doubt, you'll come back to it. But what I want to know is what they were doing in the way of learning all such details in respect of him as are required by virtue of that paragraph.
Well, what UKIP were doing,
yes.
Virtually nothing. I mean, that's even the learned district judge, who was clement towards them, and found they'd really taken no steps at all. They'd done it on the basis of his say-so. Yeah. I'll show you if I may at the end of my submission, when I seek to go just a little bit into what are in fact the agreed facts. Yeah. If your lordship go to part 2 of appendix, this is sections A and B at page 472. 472. It's paragraph 16. This is yes, tab 5. It's paragraph 15 and 16. In 2003, I went on the electoral register one of my properties, although I've not actually ever resided at this address. I was registered on the electoral register with the Thanet District Council between December 2003 and 4. I was not on the register from December 2004 to December 2005 due to a simple administrative oversight. My learned friends Junior, I think, has handed to your lordships a helpful summary of the legislation. We've not had an opportunity to check it, but I think it gives some detail of the statutory scheme. Then he says the usual procedures, the local authority send out a form to be completed annually for the person who remained on the register.
What have we just got?
That was a sheet.
Did you not receive from my learned friends Junior?
Oh, I'm terrible. I thought it said from your Junior. Sorry.
No. We were trumped or anticipated. And then there's the annual form, which I think many of my lords recollect from their own previous experience. To the best of my knowledge, I signed the forms to continue on the electoral register each year. I was not registered, etc., etc. Then it was confirmed he was on the register between 1st December 2005 and 30th November 2006. My apparent failure to register for 2005 could be my mistake, or it could be a mistake by the local office, or the form could have been lost en route. And that's as much as we know. We do know quite much about what UKIP and their treasurer were or were not doing, and that's summarised in the learned district judges doing just effectively Mr. Bowen's say-so, and a failure thereafter to check, notwithstanding repeated requests by the Electoral Commission during the very period they were continuing to receive these donations. That's why.
But Mr. Bowen was giving an address which he asserted was on the register. Is that it? Well, your learned junior is shaking his head.
No, I don't think there's any evidence that, as I understand it, and it's summarised in the factual findings of the district judge, and it's not diverted from the statement of facts and issues that we've agreed, he simply told someone, I'm on the register. And they accepted it.
When? In 2003? When he was in fact on the register?
Well, shall we go to, I mean, I don't want to be entirely in your lordship's hands as to how I develop this, but one could look
Speaking for myself, it would be quite helpful to have the schedule. If you have a schedule.
Yes, I have, yes.
Well, I don't know whether my lords would wish to see it, but speaking for myself, I would just like to see how it fits in with the...
It is quite useful to see, yes, it can be handed to my lords.
Yes, the district judge's finding is the one we've got to go by, isn't it?
Yes.
Paragraph 15, I accept the evidence of the current treasurer that he sought the assurance of Mr. Bone that he was indeed on the electoral roll.
Where do we find this?
That's paragraph 15, page 243 in the core volume.
Yes.
But the party didn't actually check the electoral roll.
Exactly. No checks at all.
What was the date? That
Well,
relates to?
between December 2004 and January 2006 is all we can say from the district judge. There must be some evidence somewhere about it, but in the oral evidence.
Yes, I mean, in the statements of facts and issues, I mean, I'm very happy to go to it now. I was going to come to it at the last stage of submission, but we were right through 2005 asking where the address was.
When was Mr. Bowne first making donations?
We joined UKIP in 2003, didn't
Yes.
he? So I think he's been making it ever since then.
Yes.
So the schedule you've just provided, is the first of those his first donation, or the first donation when he was not registered?
The latter.
The latter.
Yeah.
So it has to be looked at in the context of previous history.
There is a little highlighted passage at the start saying he was registered up to end of 2000.
Well, my question is, was he making donations during that?
Oh, yes. Yes.
Do we have a schedule that shows that?
No, I'm not sure we do. I don't think that was ever gone into.
Because if one were considering the facts,
Yes.
one ought to look at the whole context of the thing, look at the picture. It's what he told them the first case when he was on the register, and how it was that things changed. And was it just oversight? All these are questions
Where
which
was that
one would think were
return
relevant.
we were showing yesterday at some point? We were actually showing, were we not?
Yes.
Where was that? You know, the return by UKIP to the Electoral Commission, as I understand it, which showed with various addresses. We saw
Is it the
that.
back of somebody's
Oh, yes. Yeah. It's referred to in paragraph 10 of the Statement of
It's
Facts and
in
Issues.
part 2A and B, round about.
Maybe,
Round about page 85.
yes.
Yeah, sorry, this is...
It starts at 46, my lord.
We were showing 80, 81.
Yes, that's right. Yes.
There's no doubt at all that on the agreed Statement of Facts that he made donations, total donations, excess of £1 million, and the forfeiture is only in relation to something over a third of that, those being the times it's not on the electoral register.
And were the previous ones...
Sorry, but this exhibit, JF1, where does it start?
It's
46, my lord.
I know, what date?
Oh, I see.
But seems to start in July.
It's a quarterly report for the fourth quarter of 2004. We see that at page 46.
The earliest thing is July.
Well then, but you mean
July.
the last quarter of 04, because he was registered, he was okay for the first 2 months of the last quarter of 04.
What happened was, and again the statement of agreed facts stipulates this, the Commission, when they received these returns, sought to check whether Mr. Bone was on the electoral register in relation to any of those addresses, and they were not responded to. I mean, despite repeated reminders. And in many ways, if one asks about them as an enforcement agency, they were reasonably generous. They gave every opportunity to UKIP to persuade them that he was
Did they think he wasn't on the register?
Sorry?
Did they check the register and found he wasn't on the register?
That's what, exactly.
That was the position.
That was the
Did they say to him? Did they say to the party, he's not actually on the register?
Well, they kept on asking when we can't find him.
Slightly different. Did they
what's
say
the position?
Did they say we've checked? He's
Well,
not on the register. What's your position?
They did eventually say that in December. Yes.
In December of
2004.
No,
Five.
December 05.
13th December 05. But page 47, the last entry, I mean, at that point, as I apprehend, he was on the register.
yes. That's right.
Yes, because he came in again at the end of that particular year.
No, 2004,
2004, he was
still on. Page
12th of
47.
November, he was still on the register.
On the 12th of November, yes.
That's what I'm saying. That last entry
It's
was
okay.
okay.
That was okay.
Yes, I mean, that's all, this is all, I mean, your lordships ask, as it were, for the original documents. This is all in the statement of agreed facts.
No, I've no doubt.
Well, it isn't all in the statement. How much had been loaned or given, but while he was on the electoral roll before he was nominated?
Well, what we know is that he's given sums in an excess of £1 million. That's paragraph 3 of the statement.
My question is, how much of that
since
was
2003,
before December 2004?
well, it must have been approximately that sum, less that which is sought to be forfeited.
So a lot.
So there's no later. Does he go back on?
Yes, he does.
And does he give more money then?
He goes back on the register.
But does he give more money then? After he goes back on it, does he give more money? And is that part of the million?
I don't know whether that's done. I'm not certain that we know that. Whether or
So
not.
it may not be right to say that he gave beforehand the 1 million less the amount he did.
What is clear is that
He gave something.
according to the
before.
district judge, paragraph 12, page 243, he made some 60 personal donations to the party prior to December 2004.
Yeah,
so, assuming they're all over 200,
Yeah.
he clearly gave a fair bit.
Yes.
But who knows how much.
In a sense, yes, it's not quite, as it were, how much, but
How often?
how often.
Yes, right.
Exactly, yes.
And the commission had checked him out beforehand and found it was okay, had they?
Well, yes, there's a coincidence between the electoral register and his addresses. It's when there appeared to be a divergence between the two that they started pressing UKIP to explain the position.
I mean, UKIP, the Electoral Commission get these quarterly returns,
Yes.
like we see at page 46 onwards. And it's at that point that they do their check.
Yes.
I see.
And it's because the checks appeared to suggest that Mr. Bone was not registered at the addresses that appeared on the reports that they started to pursue UKIP. And instead of UKIP responding, making themselves proper checks, coming back and putting their hands up and saying, what should we do now? They simply delayed and delayed and delayed and refused to make any positive response at all. And then finally, in December of 2005, they agreed that he was not, in fact, registered as an elector. But to Mr. Smith, I mean,
I'm going to be very task, but just compare the schedule that you've just given us. I mean, we've noticed at the bottom of 47 there was a legitimate one, 12th November, right? Then the next one I can see from Mr. Barnes is in fact top of 49, 12,475. Where do we see the 5,416 3rd December?
It's the wrong date. The wrong date, is it? And in this it says the 9th of December 05, whereas on your schedule it's 2004. I think that's the wrong date.
That's yes, one's looking at 05 at that stage.
Yes, that's rather bizarre.
All backwards.
I mean, I think all that your lordships need to know for our purposes is that during 2005 there were a sequence of emails from the Commission asking Mr. Smith to explain the donations, which were referred to in the parties' returns because they couldn't find any evidence that he was a registered elector. Finally, it was admitted at a meeting on the 13th of December, that is some 7 months or so after the Commission first taken the matter up, and as is stated in the agreed statement of facts, Mr. Smith, as the party treasurer, said he did not personally check the electoral register. He relied on others at the local level, knowing whether or not donors were registered. Well, that is not, in our respectful submission, coming within any distance at all of the obligations that were
I'm not
imposed.
disagreeing. All I'm trying to do is to understand the paper.
That I do understand.
Some of them, as far as I can see, some of them are cash donations, and others, for example, the ones on page 49, are non-cash. Because it says non-cash, and see, donations. It's terribly difficult to read, but it is there. For example, you find it's clearer on, say, page 51 in the middle. It's 176, and the nature of the non-cash bequest or donation is football tickets, £176. So that's some of the sheets are non-cash and some are cash.
And it isn't. It's not.
Very annoying document.
Where did we get these?
Nature of
Non-cash bequest or donation.
non-cash request, yes, I see. Football tickets, well, that's a good one.
Paying the bill.
And Mr. Beloff, I've been looking at the emails attached to Mr. Smith's evidence later in this bundle at around sort of 4:40, 4:45, 4:50 in tab 4. One gets the impression of sort of rather, from the UKIP's point of view, an amateur operation conducting the sort of discussion you might see between two commercial parties, where one is pressing the other to get on with it performing properly. But it's a sort of rather amiable series of exchanges about a number of people. I don't know whether that's in the slightest relevance, but there isn't any reference to the fact you're committing criminal offences potentially, or this could lead to forfeiture. It wasn't conducted in that sort of vein at the time.
Well, that may well be so, but really one could be excused from the Commission's point of view as saying that someone, in particular the treasurer of a party, ought to be very well aware of his obligations. Mr. Smith has never said, I never appreciated that the law applied. And indeed, again, I've been obviously seeking to respond to my Lord's question, taken as it were out of order, but there is evidence that there had been a previous incident which should have disciplined
Previous treasurer, yes.
the previous treasurer, but then Mr. Smith took it upon himself to remove from one of the documents that the UKIP themselves provided to their donors a form that would indicate the address. So really he exposed himself to the possibility of error rather than reinforce
All
it.
this goes to the point at the very end of the case.
Yes, it does. But
Yes.
my Lord,
Otherwise,
I'm
it's
going to
sort
say,
of.
I didn't start this hair running this time. But I will.
I mean, some of us might think this is just the sort of matter which should be, if necessary, be remitted to the district judge to consider.
One might say that after 3 days in which both sides had the opportunity and were represented, in particular, UKIP was represented by leading counsel, that factual matter has been explored fully, and one really shouldn't, as it were, have a second time around.
How much money had been given before this started? We don't know.
That we don't know. But I would.
To my mind, that's quite relevant, because you have to look at these things in the context, and these electoral processes are quite difficult. We all know the difficulties of checking it out, and you think, oh gosh, am I on it or not?
But they're not difficult to check out, as I've just sought to show you. I mean, the party on whom the obligations are imposed, as I say, we need to concern ourselves with Mr. Bone. I mean, it's an accident and he's not to be blamed. It's the party who is to be blamed. They had an easy means of checking, which they simply, on the agreed facts, never took. The reason the district judge's judgment is so sparse is because the district judge took the view he's not a foreign donor in any conventional sense, therefore I don't really have to look at very much more until such time as the UKIP actually became aware that he was not on the electoral register. Even Mr. Justice Walker, who took quite a generous attitude, said he found it very difficult to understand how the district judge, in the period in which UKIP were constantly being reminded by the Commission that there was some question mark, how they, in those circumstances, those particular donations should not have been forfeited. But it is, as I say, there it is. I mean, we were looking at the legislation. The legislation imposes the duty on the Treasurer. The legislation refers to obligations in relation to individual donations. I'm going to come to the role of the Commission in a moment, but one can see under 58(2), they merely, as it were, put the matter in play. It's for the court to decide, and perhaps one would reinforce the only nourishment one gets from 59(3) and for the appeal by way of rehearing, and 59(2), the ability of the registered party to appeal without any such opportunity given to the Commission, is that reinforces the fact that it is the judges at either level who are in fact going to decide the matter. There are, as it were, 2 bites at the cherry as far as the registered party is concerned. One matter that my learned friend did not refer your lordships to, but maybe of some help again in the issue of construction, in particular into the all or nothing issue, is in relation to section 65, which deals with the separate subject of submission of donation reports to the Commission. And there are obligations, again, imposed on the Treasurer of the party. And again, there are criminal sanctions imposed upon the Treasurer, again mitigated by amendments made in 2010, a reasonable excuse defence. But subsection 6, this is 65 subsection 6, where the court is satisfied on application made by the Commission that any failure to comply with any such requirements in relation to any donation to a registered party was attributable to an intention on the part of any person to conceal the existence or true amount of the donation, the court may order forfeiture by the party of an amount equal to the value of the donation. There are 2 matters that are relevant in there. One is to note that at this juncture, state of knowledge and intention is relevant to the forfeiture sanction. Contrast section 58(2), where there's an express omission to any relevance of such a state of mind. And secondly, of course, it's a reiteration of the phrase equal to the value of the donation, which in our respectful submission shows that we're a consistency of approach, a deliberate choice of vocabulary.
Could you find yourself then liable under 65(6) without at the same time being liable under 58(2.
Yes, if you hadn't delivered in time.
One's to do with donation reports, which you have to make on a recurrent basis, and the other
Receive
to
it,
do
but
with
suppress
receipt
it.
at a particular
Yes.
time. Yes.
But you said relevant. Actually, it's different. Here it is a precondition that should be
Yes.
knowledge. Doesn't mean say it isn't relevant
No,
under the previous, under Section 56.
It doesn't necessarily lead to that conclusion. It's indicative of the fact that where Parliament thought that was a relevant feature, they built it in.
But the Court of Appeal accepts it's a relevant feature in extreme circumstances.
Yeah, yes. So that's...
Mr. Ralph, sorry, supposing that a drug baron gives money to a party, is that of any concern to the Electoral Commission?
It's the target. I mean, again, going back to what I'm loosely called the primary mischief, to adopt my learned friend's vocabulary without suggesting there aren't other mischiefs too. It's foreigners, not forgers or fraudulent, as far as one can see.
They don't bother about drug.
It's not that they don't bother about it. They're not given a
They've no power.
They've been given no responsibility.
They've got no
for it.
responsibility.
And there are those who consider that the legislation could require amendment.
Well, I mean, as far as Mr. Brown was concerned, they weren't.
Exactly.
They had no interest in the fact that he was a crook.
No, exactly.
No.
I mean, that's a
Only
very good
question of whether
example.
he was a foreign crook.
It's a very... Sorry? Yeah, yes. I mean, but what would be the criminal offence? Money laundering, yes. I mean, there could be criminal offences, money laundering and the like, which would be the responsibility of the prosecuting authority.
Yes, of course. Yes.
Not of the Commission.
Not of the Commission.
Not of the Commission.
That's the Commission that I was really getting
Roger made, yes. So before I then come to the particular submissions, can I just say, I mean, there are three just matters that I wish to leave in your Lordship's mind after this travel through the Travo and the Act. I mean, the first is that there was indeed a fundamental change between Neil, or even pre-Neil, and the Act, which meant, as the Court of Appeal said at paragraph 45, the test that was adopted to identify a permissible donor inevitably meant that some donations which could not possibly be described as foreign would have failed the test, and it was that test which the criminal and civil sanctions were designed to reinforce. The second point is that unlike the vehicles which were referred to as the trilogy of customs and excise cases, in which my learned friend referred orally to one only, one was there concerned with property that was lawfully acquired by their owners, which was forfeit by way of sanctions, whereas under Purpura, the point is the party should never have received the monies in the first place. So there's no read across at all between those cases. And the third point is that what happens here, if the forfeiture sanction is in fact imposed, it simply restores what was the proper status quo ante. That is to say, the party cannot retain money it should not have, and if it retained it, of course, it would be to the correlative disadvantage of competitor parties whose funds are legitimately acquired. And all those matters in our respective commission have to be borne in mind when one comes then to consider the points of construction which are in the forefront of your Lordship's agenda. So can I then come to the presumption issue, first of all? We deal with this in our printed case between paragraphs 45 and 75. I start on a matter which we say has never featured before. I make no complaint about that. We say it's not directly relevant. But what is the role of the Commission? Well, the role of the Commission, clearly, under Section 58, subsection 2, is for it to decide, and it is the only body or person vested with the power to decide, whether to make an application for forfeiture to the court. It is then for the court to decide whether or not to accede to the application. with great deference to my lady friend, I could not understand the submission he made that somehow the Commission's approach violates Lord Neil's principle that the Commission should not be a judicial body. It is not a judicial body. It engages machinery in which the court becomes a judicial, the judicial body. Now, in exercising its function, it is subject, in our respectful submission, to the familiar public law constraints. It must act Wednesbury reasonably, and it must pursue, as it were, the Padfield purposes of the legislation, and in principle, it would be amenable to judicial review were it to violate those principles.
What principles should it decide?
Well,
do we have any information, and what principles should it apply in deciding whether or not to prosecute?
Well,
bearing in mind the interests of other parties. Whether or not to apply for forfeiture.
Apply for forfeiture.
Bearing in mind the interests of other parties.
Well, I've caused inquiries to be made because this was not put in evidence or asked for in evidence at first instance. They do have an internal, and I stress for the moment, internal guidelines, of which we have copies, if your lordships would like to see them. They are somewhat, as it were, anodyne in the way in which, are your lordships happy to receive these?
We'd rather like to see them.
Yes. Have we got copies of being provided?
May I, please?
Yes. Go on.
Thanks.
It's really once we go, I mean, there's as it were, a reprise of the Act in lay terms. It's really at the last page, the assessment guidelines, and it's 3.1 and 3.2. As I say, it is relatively anodyne, and certainly with our respectful submission not subject to any criticism. The Commission will consider all the relevant evidence information available before deciding to apply for forfeiture an amount equal to the value of impermissible ordination. In all cases where the Commission is clear that Section 58 applies, the Commission will apply for a forfeiture order unless there are reasons to conclude that on balance the public interest is such it would lead us to exercise our discretion in favour of not seeking forfeiture. I interpret that as meaning if the preconditions for a Section 58 application are met, i.e. that there has been receipt of monies or donations, I'll use the broader term, from an impermissible donor. Then 3.2, pure Wednesbury, the Commission will have regard to all relevant considerations which may include steps taken by the regulated organisation or individual for the verification of permissibility, steps taken by the regulated organisation or individual in relation to acceptance or return donations, any other extenuating circumstances that may be relevant. And then these are guidelines intended to ensure consistent and structured decision-making. They do not fetter or limit the discretion of the Commission, and are guidelines only the Commission will consider each case on its own merits in accordance with the proper exercise of its statutory discretion whether to apply for forfeiture.
What's the date of this document?
Well, it's February 07.
What is it?
February 2007.
Thank you.
It would it not be very odd if these discretionary matters gave the Commission a wider discretion than the Court had?
Well, yes, but the way in which the Commission puts it there is, in fact, in our respect, Commission, to reflect the presumption issue. You start off by saying, if the preconditions for an application are satisfied, that is what we will do, unless there are reasons to conclude. Yes. So you start off from what we say is the presumptive position, which is what we say the Court should start from.
Yes. But would you object to the district judge applying precisely the same approach?
Not under the umbrella of the presumptive approach. And indeed, I mean, as one's thinking as always has developed during the course of debate before this court and its predecessor, we recognise that the presumption issue perhaps goes more to, as it were, what the starting point is than to the reach of the considerations that one would take into account to displace the presumption. I mean, one could have, as the Court of Appeal accepted, and it was the submission that we made that was responsible for it, that the gateway, as it were, that there's a very narrow range of considerations that could displace the presumption, but one could reach the conclusion that the presumption could be replaced, taking into account a wider range of considerations, but that wouldn't do violence to our basic point that the starting point, as it is for the Commission, should be for the judge, that there should be a presumption in favour of forfeiture. And I'll explain why.
The Court of Appeal say you must exercise your discretion to forfeit unless it's a truly exceptional case.
That's right.
But I mean, I'm not sure that 3.1 and 3.2 require a truly exceptional case before the Commission says, well, we don't think the public interest here is in favour of forfeiture.
Yes, I mean, that's why, my Lord, I sought to say that one could moderate, as it were, the submission as to presumption by saying presumption. Court of Appeal went too far in saying only displaced in a very narrow range of circumstances. One could say presumption, but you can decide a wider range of circumstances.
There's no hint of a presumption here, is there? These are wide considerations, aren't they? Just reading this document. Any other extenuating circumstances, steps taken, all that? I mean, they're all the factors which a magistrate would take into account.
Will apply unless is the vocabulary of saying that's our starting position.
I quite understand that. I mean, obviously the public interest.
Yes.
There's maybe a question of which way the burden applies, but obviously the Commission would only act on what it perceives to be the public interest.
Yes.
But in paragraph 3.2, subject to the overriding considerations of the public interest, these are pretty wide considerations.
Yes,
certainly they're a lot wider than the impression the Court of Appeal gives.
I think that's right.
And the words on balance do suggest, underline that, don't they? You bring in all these considerations, then balance the two.
But it may be that there's, I mean, nonetheless, I mean, the starting point is of some importance. Can I just, as it were, finish on?
This seems to me a really critical consideration. I find it very difficult on principle to see how the Commission could possibly, properly, have a wider discretion than the judge. I can see it the other way around. It'd be perfectly logical to say what the Commission ought to do is investigate the facts, and if there's a good arguable case that on the facts there has been an impermissible donation, then automatically the Commission says, hey, right, it's up to the judge to decide what to do about it.
I can understand that. I mean, I was just saying, I mean, judicial review, in a sense, is available, but it's perhaps more theoretical than real. I mean, I know, for example, my Lord Walker will remember the case in the Privy Council, the Sharma and Brown Antoine, when there was an effort by the then Chief Justice of Trinidad and Tobago to challenge, by judicial review, a decision to prosecute. And the Privy Council pronounced upon, as it were, the amenability of a prosecutor to judicial review, but stressed how exceptional it would be, no doubt because, at the end of the day, a court is going to decide on guilt or innocence. And in the same way here, no doubt it would be very difficult if, for example, the Commission were to follow the approach that my Lord in the Chair hypothesised, namely, here it is, received impermissible donation, we're going to put it to the court and let the court decide. It'd be very difficult to say that that was amenable to judicial review as a decision. Actually, they perhaps...
I don't know whether the analogy with prosecuting authorities is very close, but if it is, I mean, we know from the recent case on assisted suicide that there are situations in which the prosecuting authority may take a decision which in effect preempts what might happen in a criminal court. But I'm not sure it's a close analogy.
Yes. I was just stressing because I would find it quite difficult to envisage that. I'll come to one short point at a later stage. It's quite difficult to envisage the Commission acting in such a way that judicial review was actually granted, and one of the reasons, no doubt, is because they are only the first stage, and the
they'd be much more likely to be granted at the suit of some other party if they didn't put it before the magistrate.
It's possible. It's quite possible.
Well, that's precisely the situation in which Sharma said that judicial review might be possible.
Yes.
It wasn't possible if the
Right,
prosecuting authority decided to go ahead, because then the courts could review the...
Yes, I think that's right. But perhaps Lord Walker is right, and one doesn't press the analogy, it's not so strong, but I'm just trying to envisage, because, I mean, our only point is, we simply do not understand how it can be suggested that our construction means that the district judge or magistrate or sheriff, whoever it might be, is simply being a rubber stamp. It's never been our submission that the district judge or magistrate or sheriff is a rubber stamp. What we do debate with my learned friend is whether one should start from the position that if you have received money that you should not have received, in contradiction to the legislative policy, the presumptive position should be that you should forfeit. I mean, this...
I'm clear. I mean, are you accepting now that the Court of Appeal did go too far in narrowing down the width of discretion? Are you accepting it is as wide as these guidelines suggest?
Well, I prefer not to retreat from that, as it were. I'd leave that, as it were, on the table. But what I want to adhere to is the fact that you start from the position, both the Commission and certainly the judge, that if someone has something that Parliament says they should not have, you shouldn't be allowed to enjoy the fruits of it. Because if you do, firstly, you are violating the parliamentary intent. Secondly, you're gaining an advantage which you should not have.
Yeah, exactly.
It's your competitors. We are in a political contest.
I mean, the starting point of Section 58 is that it applies to a donation received by a registered party. And then if one looks back at 56.5, then that's given quite a technical meaning, because it applies, it's taken to have been accepted by the party unless, and so on and so forth.
Yeah.
Now, as I understand it, I mean, you could have received something technically, even if you handed it back, isn't that right? If it's not been handed back within the 30 days, is that correct?
Well, if you haven't handed back within 30 days, yes, I mean, you have received it.
But even if you do hand it
But
back,
even
if you fail to keep a receipt...
That's exactly it.
Yes.
Now, you hand it back, and do you still fall within the scope of 58.1? If you'd handed it back, say, in day 35 or something?
Yes.
Now, you still say at that point, is a starting point, that forfeiture should be applied?
Well, yes, I mean, but one can imagine a situation in which you hand it back and why did you not hand it back within the 30 days?
Well, it's a good question.
Investigate. And there may be that...
What's the point at this point? What is the point, Mr. Beloff? It's not at this point. It's not stripping the party of an advantage, because the advantage has been handed back. So that's not any longer the point.
Then one has the deterrent aspect.
That's a different.
Yes, I mean there are multiple strands, actually, in terms of policy, all of which, bar one, appear to have been accepted by my learned friend. But Parliament obviously took the position, I mean, park for the moment the issue about definition of permissible donor, and let's just assume, as it were, that there is a mischief there, and you can only take from a permissible, or receive from a permissible donor, and Parliament decided that in order to reinforce that, there'd be a series of sanctions. They crafted them in a particular way. They are engaged at a particular time, but underlying it is the idea that a level playing field means that the parties receive only from permissible donors. That's the theme. And as I say, what is so odd about it is this case is the first case, so I can't talk to your lordships about precedent, about when the Commission have or haven't done something. This is the first case, and as I think the phrase that I used before, Miss Justice Walker, there are other cases parked on the runway awaiting your lordship's decision, one way or the other, as to whether they are going to proceed. But one would imagine that in the majority of cases, if there are many cases in the future, there would actually be a coincidence between the Commission's application and the judge at first instance a decision, because one would assume that the Commission would not bring before the court ordinarily something that they did not believe that they would succeed in. But the fact that there was going to be such a coincidence, in fact, doesn't mean that there's a rubber stamp. It just means that both the Commission and the judge thought alike on the particular facts of a particular case.
I mean, how different are these guidelines from the principles applied by Mr. Justice Walker?
He doesn't start with the presumption.
Well, this doesn't start with a presumption, except it simply says the matter in the public interest.
Well, will apply unless.
Yeah.
Well, I mean that's what I say is the vocabulary of presumption.
But that's not the Court of Appeal's presumption.
No, it doesn't go. No,
I mean, their presumption is quite different.
No.
So, otherwise, it's pretty consistent, isn't it, with Mr. Justice Walker's approach?
These guidelines. Yes. Yes. I mean, it is, my own view does remind me, and that's something I should have been more alert to. I mean, this is how the Commission have approached it hitherto, and of course, they await your Lordship's pronouncement, if it's thought to be germane to the decision, upon whether they've correctly interpreted their role, as to whether perhaps they should not have, as it were, put it more stringently, in a presumption that persuaded even my Lord Clerk that there was a presumption there in the guidelines.
I see that.
Yes. Anyhow, there it is. Now, can I then come to, because these points are in fact relatively short. It wasn't simply tilting at windmills, it was pushing the open door. Whatever metaphor one uses, it has never been the submission of the Commission. It could conceivably have been that may here meant must. There is a discretion, and the only issue is as to the width of the discretion. It's axiomatic in a public law concept that a discretion must be used to promote the policy and objects of the particular legislation. That's Padfield, Hornbook, classic law. We've cited, and I do want to take your Lordship to, it is actually quite instructive, the Chetnik case in Authorities 3 at tab 33, because Lord Bridge actually succinctly distinguishes between two types of discretion that one finds in legislation conferring administrative powers and functions. So this is at 33. This was the is it 33? 32. This was the overpaid rates case, and the ratepayer who paid money that he did not owe, in fact, was held entitled to recover it from the local rating authority, the Tower Hamlets London Borough Council. Even though, interestingly, at that stage, the restitution on the basis of mistake of law was not a creature that had been recognised by the courts in this country. At page 873 at G, what Lord Bridge said was this, in relation to statutory discretions generally, before deciding whether a discretion has been exercised for good or bad reasons, the court must first construe the enactment by which the discretion is conferred. Some statutory discretions may be so wide that they can, for practical purposes, only be challenged if shown to have been exercised irrationally or in bad faith. But if the purpose which a discretion is intended to serve is clear, the discretion can only be validly exercised for reasons relevant to the achievement of that purpose. And I, in our respectful submission, would submit that this particular discretion falls into the latter of those two categories. And we submit that pursuit of the statutory purposes that we've sought to identify and are to a degree common ground, that the presumption ought to be that if you have received money that Parliament did not intend you to receive, you ought to be deprived of the benefit of it. Otherwise, as I say, the playing field is then tilted against persons who do abide by their legal obligations. That is, in our respectful submission, the natural presumptive position when one has something that one should not have. Now, the deterrent effect, the general purposes that we say underlie the section, apart from that which I've already mentioned, are all, to an extent, accepted by my learned friend. The maintenance, the integrity and propriety of and public confidence in the political process, so that, as it were, we would say, persons who actually break the rules or do not comply with the rules laid down by Parliament should pay the bracket, in this case, civil closed bracket, penalty. The phrase wrongful gain or deprival of wrongful gain was used. I agree, I mean, in the sense that if one said the deprival of the enjoyment of impermissible donations in substitute for the deprival of wrongful gain, the argument we advance is not in any sense violated.
Sorry to interrupt you, but it depends what one means by the purpose of the discretion. The purpose of a provision relating to forfeiture is no doubt that parties shouldn't have monies they shouldn't have received, shouldn't retain them.
Yeah.
Similarly, the purpose of the 30-day return. But you don't need a discretion to achieve that. That purpose could be achieved by simply saying they shall either be returned to the person or forfeited, full stop. The purpose of the discretion must be to introduce some flexibility.
Well, yes.
And therefore the question is...
That's why I don't entirely surrender the position that I managed to persuade the Court of Appeal. That's to say, yes, Parliament said may, not must, because they envisaged that even if the fundamental purpose of this was to make certain that the parties did not enjoy forbidden fruit, which analogy perhaps I can more easily use than wrongful gain, forbidden fruit, presumptively they should not, they should forfeit it. But, of course, Parliament in its wisdom recognised that there might be exceptional circumstances that would make that too severe a sanction. And they simply opened the door a little to that possibility.
Well, that's the whole point. I mean, where do we get a little is the question.
Well, it depends.
I mean, we can start with the presumption, but as the Commission's guidelines suggest, that doesn't mean necessarily a little.
No, but it rather depends how strong you feel the undertow of the basic principle that you shouldn't enjoy the forbidden fruit. That's the point. I mean, it all depends on your evaluation of the strength of that particular proposition.
But some fruit is said to be more forbidden than others. I mean, you know, if it's a foreign donor, well then absolutely you shouldn't.
Well, you say more.
But I mean, if actually, you know, it was a chance faulty removal from the electoral register, and there it is, you didn't check it that week, that particular donation.
Well, there may be, I mean, yes, but I think the Court of Appeal, with great respect, were right to say once Parliament has adopted Neil's approach, look at it from the other end of the lens, once they then even more tightened it by producing, you shouldn't then, as it were, use the discretion to scurry around at the back and say, we're going to undermine all that. We're going to look to see whether this person could really properly be described as foreign office. Parliament has said an impermissible donor is defined by X criteria.
Also, the whole idea of this undertow,
yes,
while I quite accept that it exists,
yes,
one has to bear in mind that they've used both the idea of forfeiture came from the Neil report, who uses the word forfeiture not really as forfeiture at all, but as a penalty.
Civil penalty.
A civil penalty. Now, if you're just talking about a civil penalty, then the idea of the undertow is not quite the same. It's simply a penalty for what you've done contrary to the statute. I mean, we can see that because we, as my Lord in the chair pointed out, that when Lord Neil thought of it, he was going to have 10 times the value. There was no forfeiture about that. That was simply a penalty. And it may be that, in truth, this is really just a penalty. and that the idea of forfeiture
Well, it
is
isn't.
curious. I'm not saying it isn't a relevant consideration, but
It was
obviously
described
is.
as a civil penalty in the white paper, and in our submission,
And it's a
from
penalty for doing wrong,
Yes,
as say for failing to check, in this case, for failing to check up properly.
the nomenclature is less important than the underlying policy. It is clear that Parliament has said certain persons are not permissible donors. The consequence of that, one would assume, is that if you receive money which you should not have received, you ought to do something that is equivalent to returning. I mean, in one sense, the notion of the silver pen is almost a proxy for that. That is a proxy for not being able to return the actual thing, or maybe not always able to return the actual thing, something equal value. But the policy that's being pursued is quite clear. You shouldn't have this advantage.
And to my mind, a penalty is something more severe, because a penalty comes out of your net assets. This, as you point out repeatedly, shouldn't be part of your net assets. So
That's why the car cases, the vehicle cases, are simply irrelevant.
But if you have handed it back late, it would be coming out of your net assets.
Yeah, and there one would have to say it's a pour encourager des autres. I mean, there's the deterrent function. You ought to.
No, I understand that. But
And it is actually quite important, this, because my only friend made certain observations which I was wholly unwarranted about the way the Commission had behaved in other cases. But it is important that, as it were, these regimes which Parliament thought should be applied are applied, and not just, as it were, ignored or bypassed, or as it were, over-sympathetic consideration be given to the so-called hard luck. So they apply to the mighty and to the small, to the parties who now make up our coalition government, to the 300, 400-odd parties, as it were, registered, some extraordinary number. I mean,
does Esther Ranson register as a party?
she's a candidate.
As she's an independent.
You don't have to be a party.
Yes, as an independent. You're right. I mean, you do gain certain advantages as well as having obligations.
You can be a one-person party.
Raving Loonies are. Raving Loonies.
Lord Such.
I'm not sure. Lord Such is Lord.
And we probably have got somewhere, if your lordships are interested, in a list of the registered parties. But there are, I mean, one tends to think that they're the ones one sees on election night, ignoring those who got less than 57 votes or something. Actually, there are very many of them. And Parliament didn't intend you to be able to say, well, I'm relatively small and therefore I shouldn't comply.
I wonder if I might ask Mr. Beloff, if the judge keeps faith with the presumption, can his discretion be informed by his assessment of the level of culpability of the party?
Approaching it from starting from the presumption and then deciding whether, obviously if you've clearly broken the law, being entirely careless, then you're not going to have the exit route from the presumption. I suppose if you've taken every reasonable step, but you've been misled by someone who you were entitled to believe, that's to say, the registration officer who you have actually been to visit and has misled you, then...
What about the possible impact on the party?
A possibility.
The possible impact of forfeiture. That's.
No, I mean, it's the rules of the game. If you commit a foul in a game of football, you're liable to be yellow or red carded. Parliament's laid it down. And you shouldn't be in the arena if you're not prepared to obey.
The Parliament gave a discretion there, just like the referee has a discretion.
Well, yes, not to overlook, as it were, blatant fouls.
Just to decide, having regard, in the words of your document, what other extenuating circumstances there are, putting them all into the mix and doing what judges do every day of the week, arriving at a fair conclusion, having regard to the purpose of the statute, its mischief, what went wrong, the difference between the person who deliberately did it, the person who had a hopeless system, the person who just made a mistake once. These are all parts of the picture, aren't they? Whereas what you're trying to do is to narrow down the scope of the discretion,
Well,
which on the face of the statute, at any rate, is given to the court without any limitation.
Well, I'm going to come back just to Chetney to give you an example of a case in which, as it were, a presumption was held to exist, which we say we can use by way of some analogy. I mean, one of the issues, of course, is, as it were, the simplicity issue. Did Parliament, in deliberately removing all suggestions of Lord Neil for, as it were, different levels and 10 times the amount of the criminal, make it absolutely short and simple? They made it short and simple in terms of identifying a permissible donor. In our respectful submission, although, of course, they gave a discretion because they recognised that there could be circumstances in which the presumptive position ought not to be the position reached, nonetheless, we're not intending this should be an open season for everyone, as it were, to take their luck at producing hard luck stories of this, that, and the other.
Well, the difficulty about that argument is that since it's an all or nothing, in a sense, the same issues are going to arise in deciding whether it's all or nothing, aren't they? Whether the discretion should be exercised at all. Perhaps with a greater intensity if it is all or nothing.
And after maybe a few cases, it beds down as to what is actually worth bringing to someone's attention. I mean, there are circumstances. I mean, we referred to one in the printed case about failure to serve documents, etc., in which the courts have said, yes, you're obliged to do something, but in sectional circumstance you'll be excused. I mean, the court's not unfamiliar with, as it were, the notion of exceptional circumstance. And of course, my Lord Vance is right. I mean, advocates can always say, this circumstance is exceptional, that circumstance is exceptional, but after a while, they begin to realise what will or will not be considered sufficient to displace what we say is a presumption of that kind. Can I just then, can we just, let's, if we may, just go to, I'd like, if I may, just to go to three cases, one of which just to show that this notion of...
We've got all we can from Chetnik, have we?
No, well, let's stay with Chetnik for the moment. It's just for the ease of submission. Now, Chetnik is an interesting case because in that case, in fact, the House of Lords decided in favour of the ratepayer on two grounds, one of which was that the rating authorities should adopt the standards of officers of the court. That's obviously not an analogy upon which we could or do place any reliance. But there was also a consideration as the case went in its way through the judicial hierarchy as to precisely what approach one took to the construction of the section. Was it an open-ended discretion, that's to say as to whether or not the money should or should not be repaid, or was it in some way more limited, and if it was to be so limited, why? If you look at 869, you see the statutory provision that was in play. It's a bit between E and H. And it has to be shown to the satisfaction of a rating authority that any amount paid in rates on the ground that, and one goes down to E, the person who made a payment in respect of rates was not allowed to make that payment, the rating authority may refund that amount or part thereof. Now, it could be said, may refund is an open-ended discretion, all factors to be taken into account. And indeed, that was the way in which Mr. Justice Mann, as he then was, appeared to approach it at first instance. One sees that at 871, where Mr. Justice Mann's judgment is cited and reference is made to the, in this case, the Civil Service Unions case, but really it's the Wednesbury catalogue. And then Lord Bridge observes at C that the judgment does not in terms articulate any criterion by which to distinguish between relevant and irrelevant considerations in relation to the discretion conferred by Section 9. So that's, as it were, the approach, open-ended discretion, subject only to Wednesbury. Then he goes on, the Court of Appeal, on the other hand, this is between E and F, held the scope of the discretion to be limited by the purpose of the enactment. Lord Justice Slade, delivering the judgment of the Court, said, we think it clear that in broad terms the purpose of Section 9, its predecessor, was to enable rating authorities to give redress and to remedy the injustice that would, at least prima facie, otherwise ordinarily arise, if they were to retain sums to which they had no right, in cases where persons had paid rates which they were not liable to pay. In the light of this purpose, they held in effect the discretion to withhold repayment in a case falling within the section could only be exercised for some valid reason without attempting to define in the abstract term the scope of matter properly regarded as for such reason. They gave an example of a fraudulent representation by the payer, etc., etc. So there, in our respectful submission, one had the Court of Appeal approaching it, in our respectful submission, on the basis that there was actually a presumption, save in circumstances one might describe as exceptional. And one sees that one of the two ratios of the decision articulated by Lord Bridge of Harwich was to uphold the decision of the Court of Appeal. If one goes to 877 at letter D, between C and D, he said, I in no way dissent from this reasoning, that's the reasoning of the Court of Appeal, but I should myself have been content to derive the same conclusion from the broader consideration that Parliament must have intended rating authorities to act in the same high-principled way that expected by the court of its own officers and not to retain rates paid under a mistake of law. Now, as I say, I place no weight at all, incapable of so doing, on the analogy, but I do respectfully place weight on the fact that Lord Bridge and the House endorsed an approach of the Court of Appeal to what was, on the face of it, an open-ended discretion in that case, that prima facie one should, in fact, in that case, repay, if one were the rating authority, money that one should not have. And in our respectful submission, there is here some degree of analogy, because what was at play in Chetnik was in that case, the restitution of monies that the rating authority should not have received, in other words, to deprive them of what was forbidden fruit, even though, interestingly, as I repeat, at that stage, it had not been recognised that money paid under a mistake of law was part of the common law. So in our case, in many ways, is a fortiori, because here one has a statutory prohibition on receipt of an impermissible donation in these circumstances we've already explored. And in our respectful submission, the same presumption ought to apply. Why? In other words, the question, it really should be a non question, not a nonny question. The district judge, the magistrate, the sheriff should ask the question, why, given that this money had not been received, should an equivalent sum reflecting the value of the donation, if the donation was not a money donation but services or whatever, why should it not be repaid? And, as it were, the presumption being a strong one, the circumstances, our present position would be, it should be exceptional or unusual to displace. Not uninterestingly, that the example given, for example, by the Court of Appeal was someone who was actually fraudulent in respect of the payment that had been made. I mean, that is a very extreme illustration of something that would be exceptional. So we would rely on Chetnik, both for the general principle that it is not enough simply to say in relation to a statutory function that the word is may, and therefore all considerations can be taken into account. One needs to look at the statutory function in the context of the statutory purpose, and in the same way as in the Chetnik case, the Wensbury approach adopted by Mr. Justice Mann was rejected by the Court of Appeal as too generous to the authority, and their decision was endorsed by the House of Lords. So, in our respectful submission, your Lordship should reject the argument that may simply means open-ended discretion, taking account of all
Mr. Belloff, I notice that, of course, I'm sorry.
Not at all.
I thought you reached a semicolon. I notice that the width of the discretion in Chetnik was wider than you say it is here, in the sense that the discretion was to may repay that amount or a part thereof. Did the House of Lords give any assistance on how the discretion should be exercised, so to speak, in relation to that partial power of refund?
I owe this to Mr. Dillon. I readily confess that I can give an immediate answer. He says at 881, Lord Bridge, between E and F, I've not found this case easy, and I confess in particular I cannot envisage circumstances in which, on the principle I've indicated, would point to a partial refund of overpaid rates as just and appropriate. And I suspect the answer is not partial, because if you shouldn't have received in the first place, what's the logic of saying you refund only part and not all? And
there is a distinction, though. In this case, obviously everything in Chetnik speaks for refunding, because you're talking about refunding the amount to the person who has wrongly, erroneously paid it in the first place. In the present scheme, we're not talking about refunding. We are certainly talking about stripping from the party, but it would have been perfectly coherent to have a scheme which actually required refunding, because, as you point out, there's nothing wrong with Mr. Bowen. He's entitled to make any payment he likes to anyone.
Yeah, and the difficulty about that, of course, would be if you just repay to Mr. Bowen, he goes, and you get back and you, as it were, escape scot-free for having received monies you should not have received in the first place. Of course, I agree. I mean, from the point of view of, as it were, who does the money go to, Chetnik and this case are distinct. But in the case of who does the money come from and why, we say that the analogy is strong.
One sees that, but you are, in fact, entirely, and I think you yourself say, without any fault on Mr. Bowen's part, depriving him of what he intended, namely that this party should benefit, and depriving him of any opportunity to enable it to benefit.
He should have given to a party which he was aware were compliant with their legal obligations.
It might just be worth that Lord Gough seems to have found at 882G thought that he had found a situation in which a partial refund would be appropriate. Because he was looking at it from the restitution point of view, and if it had...
Oh, yes, so this was really the private law analogy that would obviously Lord Gough was such a master of. In any event, here, of course, comes the second stage of argument. We say that Parliament hasn't allowed that possibility in the legislation it drafted. We have made reference in our printed case to a situation referring to the statute regime for the confiscation of the proceeds of criminal offending. It might just be worth looking at that, just to get some flavour of the reaction of a court as to why it seems appropriate to deprive someone of assets of equivalent value when in fact they've been in breach of the law. There's just that and one other case before I pass to the second stage of the submission on the all or nothing point. This is at 31. If your Lordship still have Chetnik open, it's the predecessor case. And here there was an issue as to whether or not there should be apportionment between criminals, persons found convicted of criminal offences in relation to confiscation. And there are just two passages that are of some interest in the speech of Lord Bingham of Cornhill. At paragraph 43, at 1043, one has the counsel for the Crown's argument, which I stress was accepted. And he starts off by saying the confiscation regime serves an important internationally recognised social purpose, is penal, mandatory regime, etc., etc. And then at C, the legislation is not oppressive or disproportionate, since it does not target anyone who's not shown to have benefited financially from wrongdoing. It imposes no liability beyond what the defendant is shown to have received or obtained as a result of the relevant wrongdoing, and where the defendant's benefit exceeds the sum he's liable to pay, his liability is limited to the latter sum. It's a 1043, paragraph 43, between C and D. That's counsel for the Crown. And then Lord Bingham's conclusion across the page, paragraph 46. The sum which the appellant jointly with others was found to have fraudulently obtained from the customs was, as in law, much his as if he'd acted alone. That conclusion leads ineluctably to the further conclusion that he benefited from his offending and benefited to an extent substantially greater than the confiscation order made against him because of the deduction rates made. The order made was less than his realisable assets. It's entirely consistent with the legitimate objects of the legislation, and it requires that he be ordered to pay such sum which involves no injustice or lack of proportionality. The legislation is, as Lord Stone described it, a precise, fair and proportionate response to the important need to protect the public. Now, obviously, the analogy is not perfect, and obviously there one is dealing with serious criminality, whereas here one is dealing with breach of obligations, which in certain circumstances could lead to criminal sanction. But nonetheless, the underlying philosophy of this legislation, as of that we submit, is that you should be liable to, forfeit may not be the accurate word, you should be liable to disgorge or surrender a sum as long as it is no more than the sum which you ought not to have had in the first place. So there's an articulation in a different context of what Way 6 is the similar policy underlying this legislation, which should feed into the way in which Section 58.2 is operated. And can I just then end before the short adjournment with one other case, and it reinforces it with the simplicity argument. And the simplicity argument is really to this effect. And this is why I say not merely do we want, if possible, to retain the notion that there is a presumption to be displaced, but the presumption can only be replaced by exceptional circumstances. In our submission, Parliament has sought throughout this, and the amendments to Lord Neil's proposals are reflective of this fact, that there should be a simple scheme to administer at all junctures, both in relation to checking whether someone was or was not a registered elector, but also in respect of the operation of these sanctions. And this is the case of ex parte Shah, which is 1983, two appeal cases, 309. This was a case about what ordinary residents meant for the purposes of...
Where do we have it?
I'm so sorry. Has my Lord not... Did I not give your Lordships a reference? It's in Volume 2, tab 29. Forgive me. And I'm using this actually for two purposes, one of which is just to extract that there is a general principle of statutory construction that in respect of an operation of a complex scheme, one should strive for that which makes it simplest to administer. But secondly, in relation to an answer to a question I think posed by my Lord Simon Brown as to why it was that Parliament felt that Neil's notion of eligibility created problems that a notion of actually being on the register could cure. At 347, you will see Lord Scarborough, who gave the leading speech, referring to Lord Justice Templeman in the Court of Appeal, said that he made one point of great importance, namely that words must be construed so as to enable local educational authorities to establish without undue difficulty eligibility for an award. And then going through the detail of the statute, he then said he found the simplicity for which he was right to search in immigration status. And we say that as a matter of general principle, if your lordships are able, consistent with the apparent purpose of the Act, to enable it to be operated simply, that's to say, not to allow every application for forfeiture to be open-ended argument about whether this consideration, that consideration, or the other consideration should or should not relieve the registered party who is in breach of the law from the sanction, that is something your lordship should strive to do. But the other matter, which really directly responsive to my Lord Simon Brown's question, is this. Your lordships will see, if you go to page 309, that no less than 9 days were spent in argument about the meaning of the word ordinary resident, not entirely explained by the fact that I was one of the counsel in the case 309. And the reason that that's not irrelevant is that, as I think the note you've been handed by my learned junior for UKIP illustrates, is that one of the criteria under the Representation of the People Act of 1983 as amended is that one has to be resident at a particular place. And all I say is that the case of Akbarali does illustrate that even a word as simple as resident, even if clothed additionally with the adverb ordinarily, can cause complexity to administer. And so, therefore, the legislative choice in abandoning Lord Neil's criterion and adopting the criterion they did adopt, in my respectful submission, is perfectly explicable.
In relation, I'm very reluctant to go back to all the facts, but has the fact that Mr. Bowen says in his witness statement that he's never actually lived at the address for which he's registered played any part in this case so far?
No, as I read that, my lord, it suddenly occurred to me, wait a minute, I thought the idea exactly was that you should... It's not played.
Certainly from the notes that we've had about electoral registers,
yes,
it suggests that you need to live there. But
yes,
anyway,
it does seem... It hasn't
previously not played any part in the case so far.
It hasn't played any part, and I'm not in a position to really make any submissions on that. Otherwise, I think, rather than merely repeating, I rely upon what the Court of Appeal said in rejecting certain arguments advanced by Mr. Newman as to why certain factors that the Court of Appeal thought were irrelevant, namely that he wasn't foreign, that they were a small party, that he was eligible to be placed on the electoral register. All that is dealt with in our respectful submission amply by the Court of Appeal at paragraphs 47 through to 49, and in particular in relation to lack of knowledge. One is bound to note that whereas Lord Neil made certain recommendations in respect to enforcement that referred to lack of knowledge or intention, see at 5.42, the White Paper discarded that, see paragraph 4.15, and that both in the criminal sphere, see 56.3a now, and in the civil sphere, see 65b of the present statute purpura, when Parliament considered that knowledge or intent were relevant, they specifically spelled it out, which would tend to suggest that if they made no mention of it, this was indeed by design. I'm going to come after the short adjournment, if that's permissible, to the second argument, which is a shorter argument on all or nothing. Can I note, en passant, that my learned friend relied in his printed case in respect of the point of construction on 58.2 on what he called the spirit of Article 3 of the first protocol about free elections. That somewhat exotic submission was not pursued in oral argument, and we simply note with great deference that there is simply no basis upon which it can be said that our regime for forfeiture of impermissible donations is inconsistent with Article 3 of the first protocol. The Supreme Court recently looked at the whole issue of Article 3 in the Barclays Brothers case, and Sark, Lord Collins, epitomise succinctly the principles in the European Court of Human Rights. None of them have any purchase here. So unless I can assist your Lordship further on that point, if that's then a convenient moment, I'll pass then to the second issue. I've got to deal just with the bias point, but I can deal with that very shortly, if it's convenient.
Very well, 2 o'clock.